go to 7, officer involved shooting.
Mr. Chairman, I would like to make a motion that we table consideration of officer involved shooting case 1-48-15. And here's my reasons. This case was delivered to the CPOA late Friday afternoon, and Director Harness did a really nice job based on the circumstances of reviewing an enormous amount of information generated as a result of the investigation over the weekend. The earliest it was available to the board would have been late Monday. So that would have given us 3 days to really review this case in great detail and with due seriousness. And I just don't think that's enough time. This is a very serious case. It's going to affect a lot of people. And I think we really need the time to do our due diligence and really pursue this in a serious manner. Now, I understand from our attorney, Mr. Baker, that the parties involved, let me go back. The reason we're trying to do this in such haste is that this time limit that we've been discussing all night is coming up. And within the 30-day review period, we would have to hear it tonight. Otherwise, we would not have any input on findings of discipline. So that's the only reason we would really have it tonight. Well, my understanding from Mr. Baker is that the parties involved have all agreed, and correct me if I'm wrong, to extend the amount of time that we have to review this case in an appropriate manner and still have findings and suggest discipline that is valid and real. So for that reason alone, I would move to table hearing this case.
Till when?
Till March.
To the March meeting, and our extension is that long?
30.
Chairways, members of the board, the union, the officer involved in the city, the police department have agreed that discipline will not be imposed until after the March setting of the meeting if the board chooses to wait to hear the case until then in order to facilitate additional time for review.
I would
I second
second.
your motion. I'm sorry.
Yeah.
I was going to second, and I have a comment as well. You know, one thing I'd like to use this time for is for us to be able to review the Garrity material.
Absolutely.
And, you know, there's a lot going on here,
Absolutely.
and there's a lot that, you know, the report is complete, but there's a lot of things that I have questions
Yes.
just in reading through it, you know, the first time. I have a lot of questions, and I think that the Garrity material and some of that other material can really answer some of those questions for us. So that's why I would second.
So do we have to do the Garrity as a separate motion, or can we include
So long as there's a majority vote, you could do a combined motion to table the consideration of the officer involved shooting until the March meeting and request access for the board to the Garrity material.
All right, so Mr. Chairman, I would like to amend my motion to table consideration of the officer involved shooting case until our March meeting, and to also request a vote on being able to review the Garrity material involved in this case.
Second that.
So it's been motion and second that we amend.
Oh, yeah, that we table the
Table.
consideration of the case until March.
Case until March, and also request the Garrity material for review.
Be amended.
Okay. All in favor? Any other comments? All in favor, vote yes.
Yes.
Opposed have the same votes. Thank you. All right.
So, I'm sorry, so what, isn't there some kind of document, a letter has to be generated? Go ahead.
Chairways full board. I understand that I serve you, and I think that I would be doing a disservice if I didn't speak up about the positions that you're taking at this point. You've worked very hard to get in a position to have an impact on officer behavior and to do it within a timely manner. And if the union believes that the timelines are so important, then why are they going to waive these timelines when it involves one of their own as a victim? And if they're going to waive them for this, then they should not have these timelines at all. The 30-day review period is part of the contract, and I believe that this board could move forward and rule correctly. But I serve as your choice. I have nothing else.
Okay. So it's been decided that we will table this, so we'll continue with that. All right. Any other comments or questions?
I go back to my original question, what's the process for, like, say, don't we have to write, now that we have the vote, don't we have to write a letter, or?
I think it's just notice to the department to make access available, and the agreement would be that access will be provided to the board at APD to review the material. Reasonable access will be available to the board, so I think an email or additional notice is required from Internal Affairs to be email.
Yes, and I do believe that the ordinance does lay out the proper procedure for requesting Garrity statements.
And then the access would be at APD, so the files are maintained there. But we can coordinate that tomorrow and make sure that that's in order so that you all will have access and we can let you know when access will be available.
And what about the lapel videos?
The lapel videos have never been given special treatment under Garrity's protected in this particular way, but the lapel videos are not in the same category.
Can we watch them
Yeah.
at the same time, Lieutenant, just to save sort of running around?
Yeah.
And Chair Waits, Board Member Moore, the videos are currently not in our possession. They are at our FBI regional computer forensic lab, and therefore we would have to, or you would have to request a view access that would possibly be given to you if you are allowed to have that access. It will be given to you for a very brief time period, and you can, as far as I know, only watch the video 1 or 2 times. But I don't know the exact status or how that is handled.
So who would we talk to find that out?
Commander Jeff McDonald, who oversees our scientific evidence division, also is in charge of APD's involvement in the RCFL, and you would have to contact him.
So, I'm sorry, so those aren't uploaded just like all the other ones?
Chair Waits, Board Member Wilson, they are uploaded, but they are uploaded by our investigators who are assigned to the FBI RCFL.
Oh.
So I just want to be clear, Ed had access to see all the things that you used in making this determination, correct? So you were able to see the evidence that they used in making their decision.
Chairways Board Member Fye, I was afforded access to everything within the investigation, and I was given the opportunity to gain access to the lapel videos. It was my determination after reviewing the file that reviewing the lapel videos was unnecessary for an administrative finding.
However, in your mind, Lieutenant Garcia, you believe that there may be some question whether or not we can see all the evidence.
Chair Waits, Board Member Fine. Yes, I do not know the proper procedure because this is a fairly new process for me as far as reviewing the videos. I know that my investigator did have to request special permission to be able to view them.
Okay, so if that's true, that if all of that is accurate, then we would, if without permission to see the lapel videos or any other evidence that brought you to your conclusions, we would have to see a portion of the evidence, but not all of it, to concur and put our names on it. Is that correct?
Chairman Waits, Board Member Fine. Yes, again, anything that is stored within the RCFL, we do not have access to. That is under the FBI, not us, even though that our commander oversees a portion of it. So there is a procedure for getting those videos at this time. I am not familiar with the procedure because we frequently do not view those videos. In this case, yes, the investigator did review some of the videos, and whether or not that would be beneficial in your findings, I don't know. That would be based upon your determination. And I would,
What does the ordinance say?
The ordinance doesn't speak to the
What evidence we can see?
of the lapel videos, and I'm not aware, unless it fits within the narrow exception that applies to law enforcement, which only deals with confidential law enforcement methods and the like. The lapel videos, from my read, would be public record. If there's another exception I'm missing, I'd be interested to hear what it was, but I believe the lapel videos would be public record. And therefore, not only reviewable, definitely reviewable by the board.
Well, this is an interesting point because we should have access to Garrity information. How we get that is, this is the beginning of that process, so we need to figure out how that's going to happen. So I would ask Executive Director Arneson and Attorney Baker that
We'll figure this out.
Well, here's the thing. I mean, one of the linchpins of this whole investigation is, what did this officer see, in my mind? And my understanding is they had their lapel video running. And so I think it would be just really, really a good thing to see what the officer was seeing. If that exists, I don't know. But I don't think it's worth ignoring the possibility, much less the precedent that it would set if we were not able to see the evidence in the case that we're trying to decide.
So, and without being able to see everything, then what's the value of the extension?
Yeah.
What's the value of extending anything?
Well, so there are two pieces. Well, Chair Waits, Board Member Fine, I guess my response would be in two parts. First, we don't know that you can't see everything, and my task tomorrow morning will be to find out exactly what you can, what you can see. And secondarily, the Garrity statements, that issue has been ironed out, and there will be access to those subject to the requirements of the ordinance and the agreements that we reach with the union to facilitate that. The access will be there for you to review those. So definitely you'll have the opportunity to see that in the reports. This issue of the lapel cameras, we just need to follow up on and come to the answer on it, but there's going to be information available to review.
So can we understand that process? Get that, you're going to be working on that to make sure that we have access to the Garrity information. One of the things I'm thinking is that we might have to call a special meeting for this board so that we can review that.
Chair Waits,
Correct.
I'll chase down what it will require, what is available, and update you, and if there's a need for a special meeting, we'll follow the procedures to do so, but if not, I'll get information about the process.
And if you can coordinate, I'm sure Lieutenant Garcia would prefer we not each traipse in and they have to do all this stuff up for us.
Yeah.
And that's what you're talking about.
Maybe we can have some
special
small
meeting.
groups that wouldn't be a quorum and not have a problem with that.
Chair Wade, as we discuss process, my understanding is that our executive director spent his weekend preparing a report for us, and we've decided to wait 30 days. Well and good, but my question is, in the 30-day interim, is this going to go first to the case review committee, or is it going immediately to the full board?
It comes immediately to the full board.
Okay.
Okay, and I appreciate the work that Director Arneson did. He worked very hard and spending his weekend on this. But if there's some issues, and also this is our first shot at the Garrity process, so we need to make sure we do the right things.
Yeah.
So,
Can I ask Mr. Moya, do you have any light to shed on this, given that the city council wrote the ordinance? Can you help us with this?
Chairman Waits, Board Member Fine, I was just kind of searching through the ordinance now and looking for some answers, but I'd be happy to work with Mr. Baker and Mr. Harness on making sure that we're following
the downside of us not waiting 30 days? Now that we've already had the vote, I just want to know what's the downside of us voting tonight?
Chair Member Waits, Board Member Fine, I believe that it's worthwhile, given the nature of this case, to have additional time for the board to directly review the issues and have a full view of those things, including the opportunity to review Garrity as you indicated you're inclined to do. When this came to my attention on Friday, I was surprised to hear that we were going to be on a 1-week turnaround for the first officer involved shooting. And this is not a shooting that just occurred, so there was no clock that automatically started to move this to where it is. I understand that there were reasons for it to start moving now, which are worthwhile, including the desire for discipline and not linger indefinitely, for the process to stay open indefinitely. But at the same time, if it isn't an immediate event that has to be reviewed immediately, I immediately reached out to the city and the union to say, hey, wait a second, do we need to do this in a week? Because that seems fast for the first officer involved shooting that's going to come before the board.
Yeah, this shooting's a year old, so
Yeah.
another month is not.
And I don't think, Director Fines, Director. Director Harness is fine that they're gonna change, so I don't have a problem with that. Do you have comments?
Chair Waits, I just have a question. What assurances do we have that this process is going to unfold as described by Attorney Baker at this point?
What's your worry?
I would hate that all of a sudden something would be leaked as to how the department wants to rule one way or the other before this board has its opportunity to make its decision and have its findings. What assurances do we have that this process is going to be followed through as described?
So you're worried about an end run?
Yes.
An end run.
Oh.
They're going to usurp our
I was worried about that too.
Chair Waits, members of the board, I have a written confirmation from the city attorney and the union's attorney that this is the procedure that will be agreed to, that discipline will not be imposed until after the March meeting for the purposes we've discussed. And I have no reason to doubt that the parties will adhere to the agreement that we've reached. If they did, it would be a pretty blatant breach of trust with the board. And I think a written assurance from the city attorney and the union, this is where we are, is sufficient for you to rely on.